All right, today we're going to go over Unit 4 court cases for the AP review. And the first case we're going to talk about is Brown v. Board of Education. So after Brown v. Board of Education, school integration in the South was completed within 3 years, proceeded very slowly, was unaffected by the decision. The correct answer, B, proceeded very slowly. Brown is one of the cases that you're very likely to see the AP review, and it's a great case to look at to understand how reality political issues affect court decisions. So with Brown v. Board of Education, Chief Justice Earl Warren is going to get a unanimous decision. So he has to write a fairly weak decision in Brown to get the other 8 judges on board. Brown also shows the reality that if the court had ordered immediate desegregation of all Southern schools, it was likely not to be enforced by the executive branch, and then the courts would have been unlikely to get Congress to impeach the president. So after Brown, desegregation goes very slowly, and it's not until 1972 that you actually see the court ordering busing, and shortly after they order busing, the court decides you can only bus within a school district boundary. Next case, Plessy v. Ferguson. The Supreme Court's decision in the case of Plessy v. Ferguson stated that the principles of separate but equal facilities for African Americans was constitutional, ruled that slavery were chattel property entitled to no rights, for the first time established race as a suspect class. The correct answer stated that the principles of separate but equal facilities for African Americans was constitutional. This is going to be somewhat similar to Brown, that the court must look at the realities. At the turn of the century, if the court had ordered the South to immediately desegregate, the states would have refused. The President of the United States would probably have refused to enforce the court order, and Congress would not have impeached the President. So the court is kind of stuck having to allow the South to have segregation. Later on, these are going to be termed Jim Crow laws. Plessy doesn't immediately mean all areas will be segregated. It's a great example of what happens is once one case is ruled on, then other cases similar will come before the court. So you'll have Jim Crow laws for public education, which the court will support. Segregation, public facilities, the court will support those. And with the Plessy decision, your only option, if you're an African American, would be to argue that the facilities were unequal. You could not argue that you would be desegregated. You can only argue that the facilities were unequal. Next case, this is one of the 2 M&M cases. McCulloch was likely to show up on the AP exam. And it's McCulloch v. Maryland decision. The Supreme Court ruled in favor of the supremacy of the national government over the states, the supremacy of states over the national government, judicial review. Correct answer, supremacy of the national government over the states. So what we have happening is Congress, under the Federalists, has created a national bank. The states, in this case Maryland, does not like the bank, so they put a tax on the bank, hoping to destroy the bank. The Supreme Court steps under, and this is a Chief Justice Marshall decision. He decides or makes the decision, gets the majority court to agree that if there's a conflict between the state and federal government, the federal government is supreme. Some of the wording they'll use on this is the states cannot tax a federal entity, and they'll make the comment, the ruling, or the power to tax is the power to destroy. You'll also see terminology coming out of this case, such as the elastic clause, meaning Congress has the ability to stretch its power in order to carry out its duties. Term necessary and proper, meaning Congress can pass laws that are necessary and proper for it to carry out its duties. The next case, Marbury v. Madison, 1803, asserted the power of the Supreme Court to nullify constitutional amendments, impeach the President, check the answers of the other branches through judicial review. Check the answer. The correct answer is check the answers of the other branches through judicial review. This is one of the cases you need to know, and it's a fairly early case. Marshall is appointed, Chief Justice Marshall is appointed by the Federalists to serve on the bench. Jefferson, an anti-federalist, comes into power. What is supposed to happen is the Adams administration has issued a bunch of judgeships. They're late getting them out, so there's still a bunch sitting. When Jefferson takes over, Jefferson orders Madison not to deliver. The Federalists have passed a law stating that if the federal government does not carry out its duty, an individual can sue the federal government using the Supreme Court as the court of original jurisdiction. Jefferson lets Marshall know that if he orders him to pass out the judgeships, he'll refuse. And so Chief Justice Marshall is in a spot that the Supreme Court, nobody really knows what its power is. He doesn't want to come into a direct conflict with the president and then not be backed by Congress. So Marshall finds a way out. His ruling is solving a political question. The decision he comes up with is that since the law declared or stated that the Supreme Court was a court of original jurisdiction, the law itself was unconstitutional. Therefore, the Supreme Court could not rule on it. He actually gives the Supreme Court an enormous amount of power that they now have the authority to look at laws that are passed by Congress, signed by the president, and declare them unconstitutional. And so judicial review becomes a very powerful tool in the Supreme Court. The court is very careful using this early on. They will not use judicial review again until Chief Justice Taney uses a ruling in Dred Scott where he rules that a federal law Missouri Compromise is unconstitutional. It becomes fairly routine for the court to use it later on. Next question. Supreme Court decision in Barron versus Baltimore, 1833, maintained that the Bill of Rights was intended to prevent B, U.S. government from granting titles of royalty, both the state and government from violating civil rights, only the national government from abridging civil liberties. This case is a very early case, and it establishes that the Bill of Rights only protects an individual from infringement by the federal government. The Bill of Rights does not protect an individual from protection from the state. The date 1833 is important because this is well before the Civil War. Later on, the 14th Amendment will be passed after the Civil War, and after the 14th Amendment is passed, starting in 1920s, you will see what's called the gradual application of the Bill of Rights to the states. Next case, Gitlow versus New York, the decision that states could not abridge the freedom of expression protected by the First Amendment was based on A, the 14th Amendment, C, the First Amendment, D, the exclusionary rule of the judiciary. The correct answer is 14th Amendment. This is a very early case of the application of the Bill of Rights to the states. And as the Bill of Rights are applied to the states, it's going to be based on the 14th. The Supreme Court has never ruled that all the Bill of Rights apply to the states. They've gradually applied the Bill of Rights to the states through the 14th. An early case, Slaughterhouse, that says the 14th Amendment applies the Bill of Rights to the states. The court will look at it and decide in Slaughterhouse the Bill of Rights the 14th Amendment only allows individuals the protection of United States citizens. After the Slaughterhouse case, then, starting with Gitlow, the court will gradually interpret the 14th Amendment to gradually apply the Bill of Rights to the states. Schenck versus United States, Justice Holmes said that speech can be restricted when it, A, spoken rather than nonverbal, provokes a clear and present danger, advocates the violent overthrow of the United States. The correct answer, provokes a clear and present danger to the people. This is another one where the date is important. You have a law passed during World War I in which it is a violation of federal law to try to infringe upon the federal government carrying out the duties it needs to carry out World War I. So Schenck is protesting World War I. He's trying to stop people from signing up for the draft. When he is arrested during the war, he challenges that his First Amendment rights are being violated, the Supreme Court will look at it and say free speech is not unlimited. What this importance is to understand is the laws written during World War I, the courts will generally rule that during times of national crisis, the Bill of Rights can be limited. They're not normally going to challenge the other two branches in a constitutional fight during times of war or national crisis. Later on during World War II, the court will make a similar decision with Korematsu versus the U.S. when they decide that the federal government can intern Japanese Americans, and it's similar to World War I. You have a declaration of war. They're not willing to fight the other two branches. Next case, in what case did the Supreme Court rule that a suspect must be told of their constitutional right to remain silent, and that anything they say can be used against them, and they must have an attorney present during any question? The correct answer, Miranda versus Arizona. This is an application of the Fifth Amendment rights through the 14th to the states. You also have a whole series of cases. MAP is an earlier one, where the MAP versus Ohio, which you see as an answer, which the court rules through the 14th that the Fourth Amendment applies to the states, meaning you must have a warrant to search a home or must have probable cause. If you don't have, the officers don't have a warrant, then the evidence should not be used in court. Same with Miranda, similar, but it's a Fifth Amendment. Suspect must be informed of his right. You also have Escovedo, which is a case applying the 6th through the 14th, that a suspect must be provided an attorney if he asks for one. These cases are all relating to rights of the accused, and the goal is to protect the defendant. One of the things where these cases get tricky is when you must be read your rights. If a person is merely a witness, they don't have to be read their rights. So if they were just asking questions, there's no individual suspicion, and the person admits they've committed a crime, that part can be used against them. But once they admitted to a crime, they should be read their rights. If their rights are not read to the suspect, then the state risks having the court throw out the confession or throw out the evidence. Also, any evidence gathered after the illegal entry or after the questioning, the term is called fruits of a poison tree. So any evidence gained from the illegal confession or gained without having a warrant, all that evidence risks being thrown out. Next case, or next issue, Sixth Amendment right to counsel in state courts, which expanded in the famous 1963 case of Gregg versus Georgia, Miranda versus Arizona, Gideon versus Wainwright. Correct answer, Gideon. This Sixth Amendment right, 6 applied to the state through the 14th, establishes that a suspect should be given an attorney if he is accused of a crime by the state. So it's a 6 applied to the state through the 14th. Gideon is arrested for a misdemeanor breaking and entering. Florida at that time did not provide attorneys for misdemeanors. Gideon has 2 convictions already against him, so with the 3rd conviction, he faces state time in the pen. He's convicted and gets sent to the Florida Penitentiary. In prison, Gideon handwrites to the Supreme Court asking the court to look at his case. They do. The Supreme Court decides that the suspect or a defendant should be given an attorney. The idea behind this is that in a criminal case, the defendant should have the advantage of the case. By not providing the defendant an attorney, it makes it where the state has the advantage. Where people often get confused with these issues, whether it's MAP, Escovedo, MAP, 4th, 5th, 6th Amendment rights, is with Gideon, even though the court does rule he must be given an attorney, he's not immediately set free. The case is sent back to the court of original jurisdiction. In this case, the county decides to go ahead and retry the case. Gideon's provided an attorney, and in this case, Gideon wins. Same if evidence is gathered illegally, the evidence would be excluded from trial. The prosecutor could go ahead and decide to retry the case, but would not be allowed to use the evidence. Last case we're going to look at is Roe v. Wade. The abortion decision in Roe v. Wade was justified by the Supreme Court largely on the grounds of the right to privacy implied in the Bill of Rights, our constitutional right to life, free exercise clause of the First Amendment. The correct answer, right of privacy implied in the Bill of Rights. What they're assuming, or what the court looks at here, is rights that are not necessarily mentioned in the Ninth Amendment are assumed to be there. So there's an assumption of a right to privacy. If an individual has a right to privacy, there's an assumption too then that there would be a right to an abortion. This also involves issues of the state. Traditionally, health, education, and welfare have fallen into the jurisdiction of the states. And so many states are upset that the Supreme Court steps in and rules their state laws unconstitutional. This case also shows what happens after you have one case. You're usually going to have another series of cases coming up. So after Roe v. Wade, people are going to bring other cases similar to the court, similar to Roe's. So you're going to have cases coming up. Must a woman inform her husband before she has abortion? Can a minor have an abortion? And so Roe v. Wade actually opens up a floodgate of cases. Later on, the court's going to decide that the states can limit a woman's right to an abortion, but the laws must be reasonable. And so Roe v. Wade are still having cases come up about it. This is the last case. Thank you.